way that referendum resolution reads is you say we want the voters to authorize us to issue up to some amount of bonds, whatever amount you settle on. And what it also says, what the ballot question also says, and I think we've had some discussion on this, we will spend up to $3.9 million during this 6-year period on principal and interest, on debt service of those bonds. And so you don't have the ability to vote the SPLOST for the full term if you choose a term longer than 6 years. But what you are telling the voters very explicitly is this is the most we're going to spend on principal and interest from this SPLOST. And that obligation obviously extends beyond the SPLOST, but you are identifying the maximum that you're going to spend. And if you get a lower rate, well, you're going to spend less than that 3.9. But you have to identify, this is our project. Our project, in this case, is the repayment of some debt. And you set what's the most of that repayment that we will do during the 6-year term. So, you're giving the voters all the pieces, and it's hard to, there's no real forum other than the Board of Commissioners can give all the information they want to about the election out to voters. There's no real legal document anywhere where you capture those things. Again, just because the interest rate's unknown at the time you're voting bonds. You don't know that until you actually sell your bond. Now, a voter could say, well, if I'm making these 20 payments and the rate's 5%, you can calculate exactly what's the absolute, if we issued all the bonds at the highest rate, that's a known number. I mean, you can solve for exactly how much interest that is. Now, that's not something you will do, right? You're not, at 5% for the whole amount probably is more than you would sign up for. But that number can be calculated. It's not, that's the very most that you would pay. I don't, again, all these are decisions for you to make, and there's ways for you to get that information now. It's just purely in the same way that you tell the voters what the projects are. When you're making those statements, those are statements of intent by the board, and those bind you to what you're going to do during this SPLOST, even beyond those resolutions. So, you can't say we're going to go build 20 new baseball fields out here, get everybody to vote for the thing, and then build one baseball field, right? I mean, you've got to say, even in your, aside from the things you actually adopt, when you go out and you talk about the SPLOST, those things have to be accurate as to what you actually intend to do. So,
Tom, it is against the law for the Board of Commissioners to go out and
it is. You cannot promote the SPLOST in your capacity as a commissioner. You can provide information about the SPLOST and what you intend to do, but you cannot go promoting, tell people to vote yes. Now, I think that's fairly obvious that if you call for the election, that's what you can. But what you can do is, these are the things we're going to build, and if the voter decides those are things that would benefit the county, so be it. But you're not. No, so you're not supposed to be out there as an advocate for the SPLOST in your official capacity. But
then there is an organization can take on that responsibility, right?
That's right. You can have groups of citizens that are in favor of the SPLOST. The rules to be careful for on that front is if you give them meeting space, like here, if you told them y'all want to get together and promote the SPLOST, you can come here and use our facility to have a meeting. You also have to provide that opportunity for a group that may be against the sales tax or against the referendum. So, it's best to have those activities wholly off-site and not to have any involvement in it, but you're not prohibited from doing that. You just have to